Should I do it? Should I do it?
Please.
Okay. Oh, hello everybody. It's Monday, it's 6 o'clock. My name's Brian Burke. I'm an attorney with Shihab Burke, and with me is...
Sam Shihab with Shihab Burke as well.
Well, it's like I said, it's Monday at 6 o'clock. This is that time when we talk about an interesting immigration law issue for the week. And our topic for today is your H-1B travel-related questions, as well as an ever popular topic, the Visa Bulletin, the November Visa Bulletin. It is out. So we will talk about that, and we will talk about H-1B travel. And as always, we will take your questions on whatever immigration-related topic after we go through our presentation.
Well, those are interesting topics, Brian. Who came up with those two great ideas?
It was a negotiation amongst the attorneys of this office, as I recall.
Well, I kind of went along with it, and I like the topic. H-1B travel
FAQs.
Frequently asked questions.
Yeah.
And also the November Visa Bulletin. So let's attack the November Visa Bulletin first and look at what has happened with it. Obviously, we've said before that the State Department seems to be now focusing on the Visa Bulletin from one quarter to the following quarter, with less emphasis on the 2 months in between.
Yeah, on the October Visa Bulletin, it said, hey, look for, we're trying to keep our movement, our usage of visas within the quarterly limitations. And, the thing I was saying is, hey, let's wait until the January Visa Bulletin. We'll get more of an idea as to what that really means. And well, we've seen some movement, a tiny little bit of movement on the November Visa Bulletin, being 1 week of movement on EB2 rest of the world. And for everybody's benefit, I'll put up the Visa Bulletin right now. There it is in a nice web browser. EB2 rest of the world, along with Mexico and the Philippines, moved a paltry amount to, I believe it's from 8th of July 2022 to July 15th, 2022.
And these are the
final action dates.
Final action
Everything
dates.
else has stayed pretty much the same. So that's really kind of it for the Visa Bulletin. I guess there's one other bit of news about the Visa Bulletin.
And USCIS is accepting?
They are accepting dates for filing for the month of November.
And dates for filing has moved.
Yeah, it's pretty much identical there. So not an interesting Visa Bulletin. I guess we weren't expecting one, right? It's nice to have gotten it at a nice early time during the month, but really, that's kind of it. I'm sure there'll be questions about the Visa Bulletin on the back half of the presentation, so please keep us coming, because it always entertains us and challenges us to answer your questions as well. But yeah, Visa Bulletin, it's kind of a no-show. I would also note, Sam, right before the presentation, I checked the end of the Visa Bulletin. Nothing really interesting for the purposes of people in our audience. Just a little bit of conversation about the religious worker visas that are kind of tied to the appropriations, which expire on November 15th, I believe it is, hoping to avoid a government shutdown. Yeah.
And we are going to hope not to have a government shutdown session soon, or government shutdown 2 sessions soon.
Yeah. Well, we were talking about that as a future topic for today.
Checked.
Yeah.
Have they elected a speaker?
I don't think they've elected a Speaker of the House yet, because I think I would get a notification on my phone, because we're a bunch of immigration attorneys. I think we have to be focused in on these.
Without a speaker, nothing can happen.
Yeah, yeah. One of the as we think about these topics, I thought, we haven't talked about immigration reform for a while, and my mental process went backward and said, well, not a chance of that. They can't even elect a Speaker of the House, let alone accomplish any business. So nobody's even introducing bills out there right now on that front.
It's not even possible.
Yeah. So, well, Sam, do you think we're going to be having a government shutdown 2 presentation?
Yeah, I wouldn't be surprised for Congress to do another extension, though.
Yeah.
Because it's incredibly embarrassing what is going on right now, and it's going to backfire.
Yeah.
So there may be an appetite for a second extension.
Yeah. Well, the big challenge, as a very brief refresher, it's basically for most people, for most employment-based immigration processes, the biggest impact that's going to be the Department of Labor shuts down in the event of a government shutdown, and maybe some slowness at the consulates, which is not something we need. Speaking of the consulates, though, Sam, that makes a great segue for our topic of the day, the other topic.
H-1B travel frequently asked questions.
Yeah.
Let's jump right into it.
Yeah, so we are going to put them right up above our heads and see what we got. Sam, a classic.
Can I use an H-1B visa stamp with prior employer name on it? Okay, well, obviously, you start. Are you starting with the easy ones?
You know, Sam, I'm starting with the frequent ones, the frequently asked questions, because it's just a frequently asked question.
Yeah.
It is probably the one I still get the most, and I'm here to give that public service announcement and say, your H-1B visa from the consulate abroad that says Company A on the bottom of it is still good after you have a new H-1B approval notice and you're working for Company B. They shouldn't bat an eye about that.
So why do they put the company name on the stamp?
That's a really great question. And they usually put, as I recall, they'll put the receipt number for the case on there as well. I don't know who that's helping. Because, I mean, yeah, I don't...
It's one of those things, we've been doing it that way for a very long time, and we're going to continue doing it that way without any logic.
That's a very good point. Well, I guess it's easier to maintain the status quo rather than make a change to the system. You know, honestly, what it should say this is valid. You know, with any USCIS I-797 H-1B approval. That would be, you know, something. I mean, because Sam, we're not going to stop getting this question because people are going to be anxious about traveling. They're going to be anxious about the documents.
It's misleading.
Yeah, it is. Yeah.
It's misleading.
Oh yeah, I don't expect to ever, to never not get this question again. But yeah.
So, so if the stamp was received today,
yep,
and then the new I-797. So let's say this guy goes to the consulate and get a visa stamp.
Yep.
On an I-797 that person presented to the consulate.
Yep.
But that person really had two I-797s. And then he leaves and he presents at the border another I-797 that was older before the stamp. Does that cause a problem?
So the scenario you're describing is, you know, you had multiple I-797s, you went to the consulate and got an approval approved visa based upon one I-797, and you enter pursuant to another one that you already had. I could think that the government might have a problem with that.
I don't.
Why not?
Circumstances have changed.
Okay. Well,
I don't think so. I mean, it is blanket. I have not seen a single question on a different employer coming into the border for the last 25 years.
I've never had that problem, but I can fathom a scenario where, you know, you got, because think of it, people get 221Gs from the consulate all the time. They get, you know, ooh, we want to know more about your client. We want to know more about your project. We want to see a letter from the client. We want to see something from your employer confirming the project. And you get that, and then you go, actually, I'm coming on this one that I had in my pocket the entire time. I don't think they have the means to easily figure that out because, and again, the policy we just discussed is the visa is good from company to company. But in theory, if there was a very, very bored government officer, they could go, in theory, go back and look at the records of your H-1B and say, so you got a visa stamp based upon petition A, and you entered 2 days later. So
what do you do? Go back to the consulate and say, hey, give me, they'll kick him out. Say, what the heck, you have a stamp?
So, didn't you listen to Brian and Sam on YouTube? Your visa stamp's valid with other companies. Well, 99%
of the time, it's not a problem. 99.9%. Let's take the next question.
Here's what I'll say. Well, obviously, Sam, you're coming to the border with, you're coming to the border with your new shiny new visa that says issued 2 days ago and a I-797 from another company. If you show those things to the folks at the border and they don't question it, I'd say, you know, you're in a highly defensible position. So I've come back around.
Good.
Yeah.
Question, and I apologize for asking difficult questions.
No, I'm supposed to answer difficult questions.
All right, sounds good. All right, number 2, what are the impacts on travel with pending PERM and or I-140 petition?
So, if you're on the H-1B visa, practically nothing, I guess is my short answer there.
There is a doctrine called the doctrine of dual intent.
Yeah.
And meaning that you can have an intent to return home because you have a non-immigrant visa. H-1B is a non-immigrant visa and the job is temporary. But also you can have the second intent of immigrating to the United States. That's what we call in the law legal fiction.
Yeah, there you go.
It's called legal fiction, meaning nobody can have two intent. And, you know, but I guess the better way to explain it, you can have either intent. That's probably a better way of saying dual intent.
Yeah.
Both are acceptable. So you have an immigrant intent, you file a labor certification, you file an I-140, and does that affect your H-1B stamping? No problem whatsoever.
I guess I'd say, in the DS-160, they're going to ask, hey, you ever applied for ever anybody sponsor you for an immigrant visa? The answer is going to be yes. You disclose your I-140 on that form. Yep. I guess I would say, Sam, where it must be clear, this would only apply to certain visas like H's and L's that allow for dual intent. If you change the topic to,
frequently asked questions on F1 student visas.
F1 student visas.
That can be a different answer.
The little alarms start going off because there's lots of visa categories, TN being another example, E2 being another example, that do not allow immigrant intent, meaning if you were to file a PERM or an I-140, that the good customs folks will say, oh, cool, congratulations, that's great. We're not going to let you in the United States, though, with your existing visa because you're not allowed to have dual intent.
Yep.
So, yeah. So let's move on to the next of our frequently asked questions. A new classic, Sam. A new classic. Whereas the can I use my visa from company A with company B is just a perennial classic. It's a year after year one. A new classic is, am I eligible for interview waiver? Because interview waivers have been a thing since, I guess, 2019 when COVID reared its head. 2
sentences on interview waiver, meaning that you do not have to appear in person before a consular officer to obtain a visa. So that is waived because it's a requirement and now it's waived. Are you entitled, or when are you entitled, or when are you eligible for the interview waiver? Brian.
So right now, still effective through December 31st, 2023, they have a very broad waiver category that allows, H's, F's, O's, P's, and Q's, a couple other categories. As long as the potential for a waiver, as long as they've been issued any other visa previously. So hypothetical is, if you're a new H-1B cap person this year and you have a B visa from when you needed to travel to the U.S. Occasionally, there's a reasonable chance you might be given a visa waiver when it comes time to actually apply for an H visa to come to the United States. So one thing I have to say about the visa waiver is it's always going to be discretionary. If they decide that you're interesting and they want to talk to you in person about anything related to your travel to the United States or what you intend to do there, it is their right as the U.S. consulate to, invite you in for an interview, which is what it is. There's also that's still in place, the same, if you're applying again in the same visa category and with expiration in the last 48 months, that's available as well. So renewal of your visa in the same category, your old visa expired less than 48 months ago. There you go. I imagine they're probably going to extend the waiver policy.
Well, there's no harm of extending it because it's discretionary.
Yeah, this is true.
So it gives flexibility.
Yeah, maybe they'll change their flexibility, but maybe they're going to give it to the absolute best people, the easiest
So the
ones.
consulate now is catching up a little bit, but they're not 100% caught up yet.
No. I mean, speaking of, relevant thing to bring up is the pilot program for the stamping inside the United States. Still no real substantive update on that. A little blurb on the U.S. Consulate in India website saying, expect that pilot program in 2024. But, crickets and ghosts in terms of details. And I could have swore, Sam, they said it was going to be in 2023. And I recall me sitting here going, fat chance in 2023, not a chance, not a chance, not a chance. There'll be one guy, it'll be like he won a contest. No, but sometime in 2024.
It was said in this year, and they cannot argue that they misstated it. Now we are not in the same fiscal year, and soon we will not be in the same calendar year. Fine, we'll do it next year. Okay, sure.
I just imagine some person applying for, clicking the visa application button and getting little alarms and confetti on the website. You're our 1 millionth applicant. You get a visa waiver.
Yep. And the next one, Brian.
Yes, sir.
What are the impacts on my adjustment or advanced parole? So what's the impact on traveling on H-1B? How does it affect my adjustment of status application that's pending? And how would it impact my advanced parole that's either approved or pending?
Yeah. So traveling on H-1B, I guess the first level I mentioned is there's certain benefits for people on H-1B visas and their dependents who have adjustment of status pending. The general rule for everybody across the board is that if you have a pending adjustment of status and you want to travel outside the United States, you need an advanced parole, because if you don't have one, we're going to consider your adjustment of status abandoned. Very bad.
Means that you get a denial.
Yeah, it's not the worst denial in the world, but nobody wants a denial in their adjustment of status. And if without an advanced parole, you can't come back, yada, yada, yada. There's an exception for H-1B visa holders. Those folks, if they can, in theory, travel without advanced parole, instead just come back on an H-1B visa, and USCIS won't consider their adjustment abandoned. So that's good. So it's fully traveling on your H-1B visa is fully compatible with your adjustment of status pending, and we encourage it because, well, it's nice to maintain your non-immigrant status. Because if your adjustment of status goes up in smoke, if you're still maintaining your H-1B, well, great. You can fall back on that and file a new adjustment of status or appeal, and vice versa. If your H-1B goes up in smoke, well, I still have my adjustment of status keeping me here. What about advanced parole impacts?
Yeah, so that's a little bit different answer for the advanced parole, right, Brian? So if it's the first advanced parole and you've left the country on H-1B, it's considered abandoned. And that you will receive a denied adjustment advanced parole. The adjustment status is not impacted, but the advanced parole is deemed abandoned because it's called advanced parole. That means the right to re-enter the United States requested in advance of my travel. So obviously you traveled, and before it was approved, so the advanced parole, the initial filing will be denied. However, if it's an extension, Brian, it's a little bit different.
Yeah.
An extension of advanced parole, if you leave the country, it will continue the process.
Well, as long as you have a valid advanced parole in your
Yes,
hand.
if it's approved, yeah.
You're talking about things that should be changed. The way they write the H-1B visa stamp, they should probably write, valid with any, I-797 from a U.S. H-1B I-797. It didn't used to always be that if you were an H-1B visa holder and you traveled outside the United States, they would consider your advanced parole to be abandoned. Should they be changing that one back, Sam? I know you just made the pitch, advanced parole, pre-permission.
I'm all for flexibility. All these archaic rules are nonsensical.
Yeah.
I'm all for flexibility.
Yeah.
Yeah.
I think it should
there's
be.
There's no policy that I can see is well served by denying application. You've paid a lot of money, waste their time, it wastes their money. There's nothing in it.
Yeah, touch wood. It's pretty uncommon, but it's very rare that we come across somebody who's lost an adjustment of status due to being trapped outside.
Because they don't travel.
Because they don't. But fundamentally, my response when something like that is threatening to happen is, well, you're still going to be eligible for a green card. This is going to be a lousy process where you have to do it through the consulate, which is just not.
You can refile the adjustments, the advanced parole, by the way, when you come back, and you're in good shape. All right, let's take the next one, Brian. All right, so can I come? Oh, that's a different one. Yeah. What do you got?
Oh, maybe. What if I travel separately from my dependent spouse?
Yes.
Well,
that's a great one. So that for me is one of the most important ones. What if I travel separately? So your spouse who is on H4 stays in the U.S. and you travel outside the U.S. and the spouse who is on H4 remain in the U.S.
Yeah.
And what happens to her status, and how long can you be outside the U.S.?
So, there are many things. This is one of those tough questions, Sam. In the world of immigration, there's no clear answer to this, but here's where my brain immediately goes. I'm curious whether you agree. It's the concept of domicile. It's if you're on H-1B status and your family's here on H4 and you have to take a business trip outside the United States and you're still working for your employer, they've sent you abroad for a week, a month for an assignment. If your home is still in the United States, plausibly, I would say, well, it shouldn't be too much of a problem to leave your family there on H4 status. Mm-hmm. At some point, though, Sam, if your employer is sending you, from the U.S. on a, very, very, very long assignment, I think that practically speaking, that somebody might have a problem with. I can't fathom them coming after somebody for it. I mean, but. Essentially, H4 status derives from, being dependent upon the H-1B. The H-1Bs in the United States, they're allowed to have their family member. There has to be some sort of limit on how long you can, be outside of the United States to really kind of lose the argument that Oh, I reside in the United States. I'm on H-1B status, and thereby my family's allowed to stay there.
You know, like you said, it's fact-driven.
Yeah, this is
It's
true.
fact-driven.
Yeah.
It's not enough that the spouse H-1B holder left the U.S. It's not enough.
Sure, no, definitely not. No.
Not enough. There's more for that H-4 to be questioned. And it has to do with, is there a job left?
Yeah, that's a great.
Is the person now really working abroad?
Yeah, I mean,
on a more permanent basis?
I'll change the facts. You know, there's being sent by your U.S. company, you know, to visit the subsidiary abroad, or are you sent by, or are you working for the subsidiary abroad for you know 6 months or a year?
Yeah.
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 Yeah. Is there a bright line? Is there a number of days, number of months? There is not. But obviously, the longer the time and the more permanent the assignment overseas, the more at risk the H-4.
Yeah.
And that's probably the best that we can do here. All right, let's go with the next one.
Ooh.
All right, can I come to the U.S. on a visitor visa, then file my H-1B change of status?
Yeah.
Short answer.
Yes.
A little bit longer answer as we're running out of time.
Yeah.
Very briefly, yes, to the extent that you did not misstate anything at the border coming in the U.S. or at the consulate telling them the purpose of your visa. So if you go to the consulate and say, hey, I'm going to go visit Disney, and then at the border you say, I'm just doing some sightseeing, and then a week later you file this H-1B transfer, it could be a problem.
Yeah.
But if everybody knows that you're potentially meeting a potential employer for an interview and potential change of status, everybody has no problem with it.
Yeah, they say you can come to the U.S. on a visitor visa and look for a job. They've resolved that sort of ambiguity right now, though I don't know all customs folks know it. But yeah, I guess it's a matter of intent. I mean, if you're coming to the United States to change to H-1B status, if you're coming legitimately for visitor and circumstances change, you know, that's kind of what I think about for that scenario.
Yep. So that's our H-1B travel frequently asked questions. Hopefully it helps you guys out, kind of figure out certain things in case you have a doubt. And we're going to jump in here to answer questions, Brian.
Yeah.
And this is when we tell people that you and I are not establishing an attorney-client relationship with our friends who are listening or asking us questions because we do not know enough about the facts of your case. We're just simply answering brief questions with a brief answer. Please do not make life-changing decision based on what we tell you here through the YouTube presentation or the Q&A. Please consult with an attorney of your choice to help you make a decision before you make that life-changing decision about your future. With that, we have question number 1 from
Bing.
Kumar Amit.
And let's make this bigger so we're not spending our wasting our time on squinting. Here we are.
Good. That's good for my bad eyes as well.
Yeah.
So Kumar Amit has a question for us, Brian.
Yes.
He says, India, January 2016 EB2, right? Should I give up American dream? Parents are getting older, would be forced to go back. Is this not injustice? Wow.
I'll answer the last question first. Yeah, it is. I mean,
it's not injustice, it's unfair.
Yeah. Okay. I mean, that's the way. I mean, this is the way our laws work. Yeah. It is unfair.
It's unfair. It's unreasonable. The whole process is unreasonable. It really needs to be redone. Now, 2016 priority date. So you've been through this process for 9 years now, right?
So EB2 priority date India born. The priority dates, final action dates for month of November are going to be in January of 2012, and that's 4 years off from current on the visa bulletin.
I honestly, with the caveat that I absolutely have no crystal ball and no ability to predict anything, honestly. But I honestly think that in the next 2 to 3 years, there is going to be a reform. It all depends, I guess. If we get a new president, it may not happen in the first term, unfortunately. If we get the same president again, and I don't care about politics, but I'd like to have a second-term president always more likely to have the courage to make changes because they're not interested in running for election again. So, yeah.
Well, I'll give a different perspective. January 2016 EB2. If Kumar Amit were in the EB1 category, that would be current by a year. EB1 is achievable. There are things you can do to sort of set yourself up better. A lot of folks coming from India are working in the IT realm where the salaries are high. Now, granted, you have to compare your salaries. I think it's always worth thinking about that. The alternative, mention high salaries, EB5. EB5 is always a possibility. The minimum investment amount now is $850,000, and that's still a lot of money. However, compared to what it was, I mean, these laws, the EB5 program's been around since 1990. It's been around since 1990,
yeah.
And the maximum investment amount or maximum required one is only $1,050,000. Now that's still a lot of money, but in terms of the accessibility of EB5, the number hasn't really gone up with inflation. It is more accessible than
ever before.
Yeah,
yes.
And that's something that's incredibly fascinating to me.
And it's current right now.
Yeah, current right now. Yeah. So there you go.
Cash Jam, I like the name.
Yeah.
Greetings, Sam and Brian. Do you know or heard that USCIS is renewing even advanced parole for 5 years? If filed separately, primary applicant initially gets EAD for 2 years and advanced parole for 1 year. Thank you. We don't have this information.
We haven't seen any, and I've heard anecdotally elsewhere that people are seeing, the same AP approvals. So separate it from the EAD, and there you go.
Yeah, we don't. All right, so here's more comments from Cash Jam. Looks like confirmed news to get EAD and advanced parole for 5 years when filed together initially, but not sure when filed separately.
So let's, generally speaking, they said the headline was EADs 5 years. They didn't say anything about advanced parole. I'm all for it if people get them, and come back, put it in the comments live right now if anybody has managed to get one of those 5-year APs. I would love to see one because I worry. I don't know. I just don't. It doesn't seem like them to give out a 5-year advanced parole because it's a travel document, and they seem to give those advanced paroles out sparingly.
All right, sounds good. Thanks, Brian, for sharing. And let's jump in here to Wesley Sundar Singh.
Yes.
Take it, Brian.
Can I travel to Canada with an expired H-1B stamping and a valid advanced parole for a short-term visit?
So, number one, I have to know what's your nationality, what's your passport. And so that's the first question.
Ooh, there's certain countries that are exempt from even the short-term travel rules. Yeah.
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 And the short-term travel rule also has to do with returning to the United States, not going to Canada.
Yeah.
So going to Canada, to the best of my knowledge, for most people, requires a visa.
You're pointing out that
can I travel to Canada?
Yeah.
Okay, and
so citizens of India, for example, they require a separate visa in their passport to actually travel to Canada.
And
sure.
also they have to have an H-1B stamp, by the way.
Well, yeah, an H-1B, yeah.
If they're applying here in the U.S., they have to have a visa, like a student visa or whatever, to be able to get back to the U.S.
Yeah, of course.
Now, assuming you have a Canadian visa, and then now you're talking about you're able to travel to Canada, so we're not commenting on travel to Canada. And if your question is, can I return to the U.S. from Canada with a valid advanced parole, the answer is absolutely yes. You can return with a valid advanced parole. You can go in, if you're in Detroit, people go have dinner.
Yeah, there's no difference. Yeah, it's that advanced parole is good for coming back from any country.
And without an advanced parole, you can have the short-term travel rule that applies for Canada, which is the visa revalidation.
Yeah.
As well. Which if you have an expired H-1B but stamping, you can have that essentially refreshed for the day of re-entering and then
Yeah,
bring it to
I mean,
the
I think
US.
the greatest point you made there is the first level. It's easily forgotten. Is can I travel to Canada at all? And
Yeah.
the Canadians won't let you in without a Canadian
Yes.
visa. Yeah.
Yes. Now Mexico seems to be a little bit more flexible for that.
Yeah.
All right.
The Ms. Paresh, or MS Paresh, I don't know. Our I-45 is pending with approved AP/EAD. Can dependent enter on GCAP if primary enters the USA on H1B?
Excellent question.
Yeah.
And the answer is
Yes.
absolutely yes.
Yeah.
No problem whatsoever.
Yeah, I mean that AP is really tied not even to the primary person's adjustment. It's tied to your individual adjustment of status. As long as that adjustment is still pending, your AP is valid.
Yeah.
Yeah.
And the MS Parash or the Ms. Parash has a follow-up question, Brian.
Also, do you think EB3 rest of the world with a priority date of 15th of July 22 become current for January 2024 Visa Bulletin? So right now it's in 15th of July. EB3 rest of the world with I see. So EB3 rest of the world right now is on 1st of December 2021, and the question is, will it get to 15th of July 2022? I don't know if I would count on that much movement as we sort of return to the normalcy of the universe with slow visa bulletin movements. If you're wondering what I referred to in normalcy, that EB2 rest of the world movement from July 8th to July 15th, that seems like classic visa bulletin movement to me. Like I would look at the visa bulletin every month and go, oh, it moved a week.
So Emily's asking, what would be the problem if they did an H1B selection similar to the H2B selection, which they split it into halves?
Yeah.
Into two halves. They can do that. I think the idea is because H2B is seasonal.
Good point.
And because it's seasonal and there are more than one season, it would be unfair to force everybody to file it in one time in the year. And then there's other reasons like one-time occurrence. So the need for H1B is temporary, is tied to other factors, and it puts some people at a disadvantage if they open it and close it in one day of the year. So that's why they split it. That's the only thing.
Well, my take on that is, it's frustrating though. I have a company in my mind that came to me that said, we want to get somebody to the United States, and I'd say, your person is an absolute shoo-in for an H-1B visa, totally meets the requirements. Oh, that sounds great, Brian. Well, you can only, get in the rodeo for those every, March, and then even then, if you're selected, the work can't start until October. I guess it's always surprising people how difficult it actually is to get a working visa in the United States.
Yes.
And one of the challenges there, at least you'd feel, I don't know, people would feel more encouraged if they could take a chance, every once a quarter.
Follow-up from Emily, asking for a friend if you have advanced parole from an I-485 and EB3, but now you have a pending I-485, AP, and EAD based on EB2. If you travel using the first AP from the EB3, will your EB2 485 and AP get denied? The answer is absolutely not.
Yeah, I can't fathom that scenario.
Yes.
I mean, generally speaking, the problem with traveling when your adjustment is pending is it's considered abandoned. And if you come back, well, you come back, and that's kind of that.
And there's no impact whether or not the person on the dual intent, let's say the person on an F1 visa or anything else, not H1B, that does not change the answer.
Yeah.
Ram has a question for you, Brian.
Ooh, please tell us the predictions of EB1 India with priority date of May 2022. That is rough. I'm looking at the visa bulletin here on the left here, and has the EB1 final action date for India of January 2017, which is years off. Now, as recently as September, they had it in, the September visa bulletin, they had the dates for filing for EB1 India sometime in, I believe, September 2022. So only about a year back. So My general response is it's absolutely baffling to me how the dates for filing have gone from 2022 for EB1 India to 2019 in just the course of a month. It seems to defy all logic to me. What I would say then is let us look at the next quarter and see where it's going. Practically speaking, my short answer would be movements of 5 years on Visa Bulletin final action dates are extraordinary things.
Forward movement.
Yeah, forward movement.
Backward movement is not extraordinary, unfortunately. Sagar Kulkarni, one of two. AC21 Portability question. If the job duties of the new offer are similar or match reasonably, would it be okay even if the first 2 digits of the SOC code are different? The answer is probably yes. However, this is the kind of thing that needs to be looked at on a specific
Devil is
case.
in the details.
Yes. So we really got to look at it very carefully to make sure there's no errors, mistakes, misunderstanding, to make sure that we're doing the right thing. So sounds promising. You got to have an attorney look at this one. Let's take the next one, Brian.
It's the back half of Sagar's, management
Original
analyst.
PERM list, the title is management analyst in healthcare, whereas the new job title QA analyst, healthcare. Both jobs, this quality assurance, validation of system as the main duties.
Yeah.
Sounds promising. I would probably need to lay it out. Management analyst and quality assurance. I'm not so sure. I would definitely want to look at it carefully. It does not make me feel good.
Yeah, because they have policy out there that essentially says, "Ooh, you should be interested." The policy basically on this says, "Ooh, if you have the first 2 numbers of the same SOC code, we love that." And you're putting yourself in a scenario where it doesn't, and thereby it sets the hairs on the back of my neck up.
A little bit, at least.
Yeah.
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 All right. Wonderful.
So let's see what else we got here.
Researcher J1. All right.
J1 researcher to J1 clinical with I-140 approved. Let's see if there's a follow-up.
I think AC21 is the question, probably. I'm assuming. I don't know.
I don't see any sort of follow-up on that.
So J researcher with an I-140 approved. I don't know.
If you get the other half of that question, if the question
we'll remember.
One,
Yes.
J1 researcher.
Yeah.
Your descriptive name.
Yes. All right. Hunt.
From
Abigail Hunt. Any idea how USCIS determine who to give the 5-year combo card or just 5-year EAD, even just advanced parole stands alone 5 years? So first of all, let's clarify. We have no confirmation that anybody's receiving a 5-year advanced parole.
I would love to see somebody in the comments tell us that they have, because that's just interesting anecdotal data. We see our approvals come in, and we file a lot of those, but I can't think of any one where I've seen.
We haven't seen 5 years advanced parole.
Yeah.
So that's one thing. Now, with regard to the 5 years EAD, it's clear they've clarified exactly who gets it, and I don't think there's discretion involved.
Everybody. Yeah.
Everybody with an adjustment of status. I think maybe. Certain categories listed in the release, they're allowed to have it. One of them is adjustment of status filers. So that's a big category. All right, sounds good, Brian. Let's take the next one.
Well, this one's from Skylimit, and I have to take off my imaginary hat and tip it in their direction, because that's one of those great common H-1B travel-related FAQs that did not make it to my list. Can we travel with new passport and old passport with the valid visa in that old passport?
Excellent question.
Yeah. Yes, they will honor a visa that's in an old passport.
That's an excellent question, Skylimit. Thank you for helping us out with our H-1B travel frequently asked question. That's the ultimate one.
Yeah.
Brian, you missed that one.
I admitted it first thing, and I tipped my hat to my hat.
All right, back to Emily. The reason I asked to see if using H2B system for H1B would reduce multiple filing issues, or is that against the statute and not allowed to be considered? I don't think there is a problem with the statute. I think it has to do with the fact that H2B is seasonal work, and there's more than one season, so they have to split it. That's the only thing.
Yeah, I mean, as a practical matter, I don't think there's anything that requires them to take all those cases on April 1st. I mean, in years travel back, to like 2016 or so, when the demand for H-1B visas was low, and they were perfectly happy to take H-1B caps, in January the following year if there were still numbers available. So there's nothing that stops them from doing that. Yeah.
Abigail Hunt, how long do you guys think they will continue to accept the date for filing chart? Why don't they release pending I45 data by categories? Well, I mean, we usually think it's the first quarter for, we feel good about the first quarter. And then after that, it's up in the air.
Hey, I don't feel good about anything. I check what USCIS says every time a visa bulletin comes out, and I act accordingly. We check our files to see if there's anybody who has a pending adjustment of status and needs to get out the door.
Yes.
Why don't they release that I-45 data by category? Because that would be very interesting. A frequent frustration we hear from people, and we try to sort of cut through that, it's the lack of information out there from the government. Like, I want to try to base my life, my planning for the future based upon data, based upon information that's available, and they don't give it out.
Well, two-part problem. One, they don't have to give out anything they don't have to give out.
Yeah.
Well, let me rephrase it. They don't give out any information they don't have to give out, meaning that the government is the least information they give, the less questioned they will be. So the more information the public has, the more smart questions they have to answer, which they may be prepared. They're not prepared to answer. So that's one.
Yeah.
There's a two. A lot of time they don't have the information. A lot of time they're not organized enough. They're not on top of things enough, and a lot of time they revise their numbers. I've done lawsuits before where files ended up in warehouses where they're abandoned warehouses.
I literally just had an RFE this week for USCIS lost an H4 case,
Yeah, this is abandoned. There was a news release last year in the New York Times about another similar to the case I had a few years back, where the file is in a warehouse that's shut down for security reason. The other case that was in the New York Times last year is about files were in asbestos-infested warehouse facilities.
Sam, I very much like that phrase, asbestos-infested warehouse facilities. It's very fun to say. Asbestos-infested. I can't say it, Sam.
Fast enough. Yes, but that's a fact. And some files were stuck there for years and years. Nobody wants to go on. You have to have a hazmat suit to go in and grab a file.
Get the files?
Yeah, and their files are there.
And then you get it back to your office?
Until you sue, So the government doesn't know, doesn't have access, too many files, too much going on, don't have a handle on it.
I imagine, when I get asked questions like this, I scratch my chin and go, well, I could put in a FOIA on that. And first of all, they wouldn't create a report for the purposes of my FOIA, and they wouldn't give me that. I would see that FOIA being denied and telling me to go take a hike, highly likely.
AWS. I have a question. I-45 filed with EB1A and now retrogress. Do I need to file Supplement J if I change employment? Well, we had a great question on that. I would definitely file a Supplement J. It does not hurt.
Yeah, they don't have any particular time frame they require you to file it on. They say you can bring it to an interview, you can submit it in response to an RFE. But our conventional advice has always been to, when a company is making you an offer, make it part of your offer to them. And you're going to sign off a Supplement J for me so I can get my green card? Yeah, get it now, because the next HR person might forget that conversation happened. You might have a headache on your hands.
Yep. Another H-1B travel frequently asked question for you, Brian.
Sam, you said you weren't so sure about this topic. I think people are very much into it.
Yes.
From Raul. Hi, if my passport expires before my I-797A expires and I go for visa stamping with my passport, what will be the expiration date given on my stamped visa? Passport expiry greater than 6 months away. So basically, there's a part 2 of it, so let's get to that. What will be the I-94 expiry date if it matches the passport expiry date? Okay, so we got to answer question 1 first.
So the first one, would they issue a 3-year stamp on the passport that expires less than 3 years? The answer is yes.
Yes. Yeah, they will do that. That's the
Yeah.
answer to Skylimit's question was, yeah, they'll honor visa stamps and old passports, and that sort of
No,
requires
no. So you go into the consulate,
Yeah.
and your passport is expiring in 18 months.
Yeah.
Do they put a 3-year stamp on that passport?
Yeah.
Yes.
Yeah, they'll do that for
Yes,
sure.
they'll do that, yes. So the answer to the first question is they will give you the maximum amount of H-1B time, which is 3 years, stamp.
That's on your I-797, yeah.
Yeah, matching the I-797 up to 3 years,
Yeah.
right?
Yeah, I'm down. I'm
Yeah.
good with that.
Now, how about if the I-797 is 1 year, would you give a 3-year stamp?
No, they won't. I don't believe they'll do that. No, not for an H-1B. No.
I've not seen less than a 3-year stamp.
No, I'm pretty sure they'll only do. I'm pretty sure they'll give you a 1-year stamp. Now, I mean, I can think of other categories where they'll give you a stamp beyond your approval. But for H-1B,
I disagree.
I'm pretty sure that
So you and I don't see. Rahul caused a problem.
will cause
You
problem.
and I are in disagreement.
I am pretty sure that they will only give you an H-1B stamp for the validity of your current H-1B approval, which would be up to 3 years. But practically speaking, it's going to be less than that because you get your approval, then you go for stamping.
We'll talk more about that. I guess we'll look it up and update everybody.
Yeah, let's go to the back half of
the
Raul's
second
question.
half is when you enter the U.S.
Yeah. So this is a great topic for Raul to bring up. So the good folks at Customs, despite you having a 3-year H-1B stamp, they will give you an I-94 usually that is limited to the validity of your passport to the day. So about once every a couple times a year, somebody comes to us for their H-1B extension and they say, "Oh, look at my H-1B approval notice. Here's when it expired. Here's when it expires, and that looks good." And then they'll say, "Hey, how about your I-94?" And your I-94 will have expired, X amount of months or even years ago because, you entered with a passport with a shortened validity period. They will only go through the end of your passport. Check your I-94s when you enter to the United States. Make sure you don't have a problem on your I-94. If your I-94 you get from Customs and Border Protection does not match your prior approved H-1B approval notice, the conventional opinion of immigration attorneys is that new I-94 from Customs will usually take that with an asterisk because there's a lot of issues related to that.
AWS, EB1 485 filed November 22nd. USCIS took wrong priority date. We found it in May 23.
I mentioned we filed it in May 2023. Yeah.
Okay. For next 3 months, struggled to get priority date corrected. In June 23, priority date got corrected, so current for 3 months. Can we use delayed litigation?
So, as I'm understanding these facts, there's a May 23rd filing of an I-40. Okay, so I'm sorry. I see. We filed the I-45 in November 2022. We found the priority date was wrong in May 2023.
You cannot use, you can, but I'm not sure you're going to prevail.
So this case has been pending less than a year at this point.
Not only that, but I think what happened to him is by the time he fixed the priority date, the window of opportunity closed.
I see, yeah.
I mean, that's my reading of it.
Yeah, because I presume if you filed your adjustment status in November
By the
2022,
time, by the time it was fixed.
presuming this person's from India.
Yeah. The problem with a delayed litigation is basically, again, it's a writ of mandamus. Delayed litigation is nothing but a writ of mandamus. A writ of mandamus is a request to force the government to do their job. If the government, at the time the case is filed, does not have a visa to hand out to you, a writ of mandamus will not fix it. A court decision cannot circumvent or bypass the congressional intent of handing out certain number of visas per year. So if they ran out and give it to somebody else, a court is not going to go force the government to take the green card from somebody and give it to you. And therefore,
if we're out of visas, we're out of visas.
Yeah. Therefore, delayed litigation does not work. The most difficult one I dealt with many years ago deals with the lottery selection. And this guy was incorrectly denied at the consulate. And by the time we made it to the court, we passed the congressional date.
Yeah, they put that number back. They took it away, put it in the next. Yeah,
there's no remedy.
Yeah.
No remedy for that guy.
Yeah, that stinks.
And that stinks.
Yeah.
So that's my opinion, but maybe another litigation attorney have a different opinion.
Yeah, I mean,
absolutely, you can talk to other people.
I see a pending case from November
I'd
2022.
file the lawsuit the moment the visa availability again opens up,
Yeah.
and not file it right away.
Yeah.
100%.
Yeah. I'm assuming the visa's not available right now for sure. If they robbed you, if your visa was.
And if the visa is available, and his question is, do I use delayed litigation because my visa is available and they delayed me for 3 months?
Yeah.
That's not enough delay to get a judge impressed with your case.
I mean, at the highest level here, I see an I-45 filed in November 2022. That's in less than a year. And I basically would tell anybody right now, how long should it take your I-45 to be approved? Oh, about
year and a half.
Yeah, a year to year and a half. Yeah. So let's check out this question from Himanshu. EB1 India, priority date 2012. My priority date is current as dependent applicant. My own employer is willing to start my PERM process. Does it make sense to go through the process given the time that it takes to get to 485? A very good question, I think. So basically, you have a spouse who, you're the dependent, and this person has a spouse or dependent, and a path to a green card that is imminently available, either already is current, meaning there's probably a pending adjustment status out there that could be approved imminently. Do I ask my employer to file a PERM knowing that my date is probably, a decade off from being current? The immigration attorney in me has a sort of, which is what I am, has the old adage, don't presume the green card's in your hand until it is in your hand.
But I think the question he asked is answered by the following question that I will ask him.
Okay.
Do you have the patience to wait 15 years for a green card if your wife's green card is not, or spouse's green card, I should say, is not approved? If the answer is yes, file a new PERM. If the answer is no, don't.
That's a great perspective on it. If this gets denied and you're done in the United States, why the heck would you pursue another path? Yeah, that's a good point.
Yeah.
Let's see what we got here from
Rahul.
Rahul.
Hi, for how long do I need to wait before I can contact USCIS for pending advanced parole? I can refile advanced parole renewal along with EAD in the hope of earlier approval, even though I have a pending advanced parole application. I would look at the processing time.
Yeah.
Which is around about 4 months now, 4 to 6 months for advanced parole.
No, advanced parole, it's far longer than that.
I thought it got improved.
No, I'm going to go to the USCIS.gov website right now.
The processing time.
Check the processing times for advanced parole. If those who aren't familiar,
8 months?
go to the, I think it's going to be way longer than that, Sam. I'm thinking you're looking like over a year, but I could be wrong. So different service centers, different times. California Service Center, 17 and a half months.
Well, that means it's shut down.
NBC. There's one of these is going to be like 10 months.
Okay.
Nebraska Service Center, and that's going to be the good one, NBC. 6 months.
6 months.
Okay, that's not so bad. Texas Service Center, 18 months. Vermont Service Center, 8.5 months. A little bit better than I thought.
Yeah. I mean, it's improving, but it's not where it should be. It's outrageous.
Yeah. So basically, when it comes to contacting USCIS, if you go to their check processing times website, you can put in your filing date, and they'll tell you whether they'll accept an inquiry. Because if you ever tried calling USCIS, they will flat out tell you we won't take an inquiry on that date because it's not been pending with us long enough.
Yeah. How long do I need?
I think this is the same question here from Rahul. And there's Texas. I mean, I don't think that was in the prior question. Texas Service Center. Processing time is I'm sorry, Rahul. 18 months.
Yeah.
On the same page though, where you put in those processing times to check them on the USCIS website. If you,
I mean, this is outrageous.
Yeah.
I mean, I think a delay lawsuit for an advanced parole is now out of the question. If you're like past 7-8 months. I'd file a lawsuit and let them argue
Can
that.
you class action in an APA?
Can't class action the government.
What?
Can't. Yeah.
You can? I mean, what? I mean, if
on an immigration processing? I mean, you can. You can.
Yeah, but basically.
A lot of attorneys don't do that because it's very.
I don't give it a great chance of success. But I mean, everybody's processing. I mean, basically, people are out there, saying, oh yeah, your best bet is if somebody's dying. You know, it's not a good.
Well, you have an emergency advance parole process.
Yeah, but you know, what can I say? It also kind of stinks to get an emergency advance parole. It takes probably about about 2 weeks to get one of the.
Or faster on an emergency basis.
Yeah, but I mean,
it doesn't have to be an emergency to leave. It's a humanitarian, for crying out loud.
Well, yeah, exactly.
Yeah.
I don't know. That's what irks me about it.
Yeah, my youngest brother is graduating from college. I want to attend his ceremony.
Okay, that's nice, but is he dying too?
He doesn't have to be dying. People don't have to die to be able to go and join family. It's outrageous.
Well, that's it.
Yeah.
You know.
That's ridiculous. Yeah. All right. Akash K, EB2 1, priority date March 2013, pending 45, more than 180 days. Green card interview also done. Okay. Job changed on EAD 45J filed. I-140 revoked by previous employer. Any impact on green card? No, I don't see it. I don't see it.
So I don't think so.
Withdrawn, not revoked. Withdrawn by previous employer.
Yeah, I would question how long that I-140 has been pending. I'm going to presume that I-140...
More than 180 days.
Not necessarily.
Why 45 been pending for 180 days?
Yeah, but you can file the I-140 simultaneously if it's not filed with premium processing. But if the
more than 180 days. I mean, unless you do a transfer underlying basis.
But no, imagine it. You file an I-45 and I-140 in the same envelope, and if that I-140 is not approved, I mean, technically you're eligible for portability after. But if the I-140 is not approved, you have a problem. You know. So if that I-140 is approved for more than 180 days, you just have to find a new. Well, you already have found a new.
So
company.
has the I-140 been pending? Has been approved more than 180 days? Is your question?
Yeah.
Yeah. And if the answer is yes, there's no problem.
Yeah. That would be my take on that. Yeah. Let's see what we got from Subramani Kumar.
I had interfiled and downgraded to EB3, and is now current. Is there anything else I need to do? Will submitting the medical exam help move the file? Thank you.
Well, congratulations.
Well, you need to irk the USCIS. You need to get on top of it. If there's no response, I would sue.
Well, for me, I think I would start with sending, if your priority date has not been current for a while and now it is current, I might start with a polite letter to whatever office has your case. We used to do them a lot when prior to 2019 when things went.
But if things don't move, I would sue.
Yeah, oh, for sure.
You gotta act anymore because now you have it, tomorrow you don't.
Yeah.
You need to get out, get that green card.
If it's been current for a while and the Visa Bulletin is still subject to doing wacky things right now, I'd be keeping a close eye on it.
Yeah, I will evaluate the case for a lawsuit.
Yes.
All right, take it, Brian.
So, from Parole again, how do I get my I-94 corrected after my passport renewal if the previous I-94 expired due to my passport expiring? Do I need to re-enter the United States? Yeah, this is concerning.
Yeah.
So, generally speaking, you cannot get your I-94 corrected after an expiration due to it being synced up with your passport expiration. And the answer would be you need to re-enter the United States. Now, this is the sort of thing where I would immediately advocate talking to an immigration attorney personally on the phone or in person of your choosing, because these issues are serious.
I wouldn't leave the country without talking to a lawyer, because if you've been without an I-94 for an extended period of time, like 180 days or more, there could be some severe penalties associated with the staying without a valid I-94. You may not be allowed to re-enter the U.S. for a long time. And therefore, it's called unlawful presence. And therefore, you need to consult with an attorney. This is in the area of must.
We're always reluctant to talk about I-94, the real intense I-94 issues here, because they are very, very fact sensitive there. Yeah.
Yeah. So I don't remember one of two.
So this is Himanshu.
I think
Himanshu was the dependent of somebody who had a current priority date. So
Himanshu, there was a follow-up after that one, by the way.
Oh, there was there? Okay.
I think so, yeah.
Let me see here. So
right there. One more down. Right there.
Oh, 2 of 2.
Maybe that. My own priority date is also 2012 and is current. Does it make sense to go through PERM to get the 485 stage? Oh, okay. So my own priority date is 2012.
And current.
Now, is that a priority date based on an application you filed, and not because you're dependent on your spouse? And if the answer is yes, yeah, it will make sense to file a PERM to make sure that you have that second security.
Yeah, I want to make sure that what you're saying is clear. Just because your spouse has a priority date doesn't mean you have a priority date. You get your priority date independently from one the other. Obviously, you can, as a dependent, you can immigrate, but you each have your own independent priority date.
Separate and independent priority date. So if you have your own independent priority date from an I-140 that you filed for you as an employee of a company back in 2012, and now you have a PERM, now you have your own separate priority date, then filing a PERM makes sense, with the hope that your wife or your spouse, I must keep saying your spouse priority date and pending application goes through, you're in good shape. But does it make sense to file a second one? Yeah, I would say it does. I think it makes sense.
Yeah, I'm all for having multiple paths to a green card, as long as they're not ridiculous ones. Yeah.
Brian, we hit 7 o'clock. Let's take one more. Yeah, let's take one more and thank everybody after that. From Satish Kumar will be the last person.
Yes.
I have an I-140 approved in 2019. Currently, I have an H-1B. Can I take state life health insurance exam and get state life health insurance certificate? Will it be considered as H-1B violation?
So?
Taking an exam does not make you in violation. But even if you attended a class to prepare for an exam, does not cause violation.
Bit of context, the government doesn't care whether you go to attend university, part-time when you are on an H-1B visa, as long as you're not your primary purpose for being in the United States.
Yeah.
But the only thing I would question is, to what end? If you're an H-1B and you're working in your H-1B specialty occupation relates to state life health insurance, great, fine. I would question if you're planning to change occupations, that can be difficult in the context of changing.
Well, he can get the license, but he may not change.
Yeah, it might be useful. It might be useful for somebody.
I think more information is needed.
Yeah.
With that, Brian, we're going to say thank you to everybody. You have a great day, and come back Monday at 6 o'clock, and we will get to answer more of your questions. Have a great day.